Faites appel, s'il vous plaît, Monsieur le greffier.
Monsieur le Senator Gorst,
Présent.
Monsieur le Senator Farnham,
Présent.
Madame la Senator Ferguson, Monsieur le Senator Lafondre,
Présent.
Madame la Senator Valois,
Present.
Madame la Senator Moore,
Present.
Monsieur le Senator Pallet,
Présent.
Monsieur le Senator Mezek,
Présent.
Monsieur le Connétable de Saint-Hélier,
Présent.
Monsieur le Connétable de Saint-Clément, Madame le Connétable de Saint-Laurent, Madame le Connétable de Saint-Sauveur,
Présente.
Monsieur le Connétable de Saint-Brelade,
Présent.
Monsieur le Connétable de Gruville,
Présent.
Monsieur le Connétable de la Trinité,
Présent.
Monsieur le Connétable de Saint-Pierre,
Présent.
Monsieur le Connétable de Sainte-Marie, Monsieur le Connétable de Saint-Ouen,
Présent.
Madame le Connétable de Saint-Martin,
Présente.
Monsieur le Connétable de Saint-Jean,
Présent.
Madame le Deputy Martin,
Présente.
Monsieur le Deputy Southern,
Présent.
Madame le Deputy de Gruville,
Présente.
Monsieur le Deputy Lewis,
Présent.
Monsieur le Deputy Tadier,
Présent.
Monsieur le Deputy Higgins,
Présent.
Monsieur le Deputy Marceau, Madame le Deputy Pennell,
Présente.
Monsieur le Deputy de Saint-Martin,
Présent.
Monsieur le Deputy de Saint-Ouen,
Présent.
Madame le Deputy Dublé,
Présente.
Monsieur le Deputy Labby,
Présent.
Monsieur le Deputy Wickenden,
Présent.
Monsieur le Deputy de Sainte-Marie,
Présent.
Monsieur le Deputy Truscott,
Présent.
Monsieur le Deputy Young, Monsieur le Deputy Ash,
Présent.
Monsieur le Deputy Morel,
Présent.
Monsieur le Deputy Guida,
Présent.
Monsieur le Deputy de Saint-Pierre,
Présent.
Monsieur le Deputy de la Trinité, Monsieur le Deputy de Saint-Jean,
Présent.
Madame le Deputy Lycra,
Présente.
Monsieur le Deputy Aye, Madame le Deputy Pershard, Monsieur le Deputy Ward,
Présent.
Madame le Deputy Alves,
Présente.
Monsieur le Deputy Pamplin,
Présent.
Madame le Deputy Gardner.
Présente.
Le doyen.
Notre aide soit au nom de Dieu qui a fait les cieux et la terre. Amen. Seigneur Dieu, Père éternel et tout-puissant, qui a établi le gouvernement et les puissances de la terre, pour le règlement et pour la conduite du peuple, et qui nous a commandé d'avoir toujours pour but la gloire de ton saint nom. Nous te prions qu'il te plaise de donner à cette assemblée le don de conseil et de prudence, donner les cœurs et les affections de tous ceux qui la composent, de la conduire tellement toi-même par ton Saint-Esprit, que toute leur délibération et ton accompagnement de la bénédiction réussissent au bien-être au soulagement du peuple, qu'il te plut de commettre à leur soin. Car nous t'en prions au nom et par le mérite de ton Fils bien-aimé Jésus-Christ, notre Seigneur, qui nous a enseigné de t'invoquer en disant: Notre Père, qui est aux cieux, ton nom soit sanctifié, ton règne vienne, ta volonté soit faite en la terre comme au ciel. Donne-nous aujourd'hui notre pain quotidien, et nous pardonne nos offenses, comme nous pardonnons à ceux qui nous ont offensés. Et ne nous envoie point en tentation, mais délivre-nous du mal. Car à toi, à la reine, la puissance et la gloire, au siècle des siècles. Amen.
Madame the Senator Ferguson,
Sir, you might have noticed from the chat that Senator Ferguson is present, but due to a technical hitch is voiceless, but she is present, sir. Thank you.
Very much. Mark is present.
Monsieur le Connétable de Saint-Clément,
Excusez.
Malade, sir.
Jure que Monsieur le Connétable de Saint-Clément est tellement indisposé qu'il ne peut pas assister aux tâches sans exposer sa santé.
Oui.
Madame le Connétable de Saint-Laurent,
Excusez.
Monsieur le Connétable de Sainte-Marie,
Excusez.
Monsieur le Député Masson,
Excusez.
Monsieur le Député Young,
Excusez.
Monsieur le Député Aye,
Présent.
Madame le Député Pershaw,
Excusez. We didn't call the Deputy of Trinity, who I think has just come in.
you're quite right. Monsieur le Député de la Trinité,
Présent.
les états sont en nombre, Monsieur le Président.
Les États sont constitués. We now resume the debate on P, the principles of. Deputy Gardner, I beg your pardon. Did you have?
Thank you, sir. I would like to advise that I will be representing States of Jersey Committee System at Lesotho Parliament workshop this morning, and I will be back for voting after 11.
Very well, so you're wish to be marked away on state's business in effect. Present, well, yes, but you're indicating it. Very well. Thank you very much, Deputy.
Thank you.
Very well. We resume the debate on P22, the principles, and the Attorney General was to advise. Mr. Attorney, are you in a position to advise the Assembly on the various matters that were raised prior to the adjournment yesterday afternoon?
Yes, sir. I hope you can hear me. My camera doesn't. Yes. Sir, I was asked, I think, 5 questions. If I may start with Deputy Tadier's second question. He asked me to confirm that we are not inventing something new by the reference to being ordinarily resident in Jersey. And so I do confirm that, give that confirmation, we're not inventing something new. The criteria of ordinary residence is already in the current version of Article 7 of the States of Jersey law and in Article 4B of the Connétable law. So as regards Deputy Tadier's first question about the meaning of ordinary residence and the effect of periods of absence. So the concept of ordinary residence isn't defined either in the States of Jersey law or in the Connétable law. But as I indicated yesterday, its meaning is clearly intended to mean ordinary residence for tax purposes. It is a well-known tax concept and it is referred to in Article 126 of the Income Taxes Law of 1961, which provides that every individual whose ordinary residence has been in Jersey shall be assessed and charged to income tax. And so the Revenue Jersey gives further guidance on the meaning of the term. The guidance provides that someone is liable to Jersey income tax on their worldwide income, regardless of where it arises, where they are ordinarily resident. And it's different from someone who lives. So effectively it means someone who lives in Jersey permanently or who intends to live here for 5 years or more. So as indicated yesterday, it's effectively where someone's home is, where they regard as being home. The Revenue Jersey's guidance also provides that a person can continue to be ordinarily resident if they live temporarily abroad on an occasional basis, but they would lose ordinarily residence if they leave Jersey for a longer period, and the guidance suggests a full year longer. So it doesn't mean, I would stress, that a person actually has to pay tax in Jersey in order to be ordinary resident. it is how they are regarded for tax purposes, and so that is a different concept in terms of being licensed or entitled or having permission to work for the purposes of the housing and employment law. In relation to the Constable of St One's question about whether it was a clear definition, in my view, yes, it is a clearly defined and well-known concept. It is used fairly frequently in our legislation, and so I've not been able to find overnight any cases reported in JLIB, or Legal Information Board, concerning where there's a dispute concerning its meaning. So that points to the fact that it's not really a contested term. It's one that is well known, and so I think it's difficult to think of a practical alternative to the term in terms of defining residence. So fourthly, Deputy Martin asked a question where she cited an example of a child who's born in Jersey and then leaves to go to university and then comes back and wishes to stand for election. Would that person be able to stand? And so my answer to that is that on the current version of the law, which simply provides for, it doesn't have a test of being entitled or licensed or entitled to work under the housing law. Under the current version of the law, where the person simply has two alternatives. They either have to have ordinary residence for 2 years, or they can have 6 months ordinary residence up to the date of election, providing they have an overall total of 5 years of ordinary residence. So on that definition, in my view, a person in those circumstances, the example cited by Deputy Martin, they probably would be able to stand for election, because simply going away periodically to attend university would not be sufficient to break their ordinary residence for tax purposes. But alternatively, if that person goes away to work perhaps in the UK or other part of the world for 1 or more years, then that person would not be ordinary resident, but so they would still be able to stand for election under the current version of the law, because there is the alternative of just having ordinary residence for 6 months up to the date of the election, and then a total of 5 years of ordinary residence. So that person would probably be able to stand under the current version of the law, but then they would not be able to stand under the proposed in the proposed draft law as set out in the proposition, because they would also have to establish that they had 5 years of ordinary residence up to and including the date of election. So that is a different and higher threshold that is being introduced in the draft law. And then lastly, Sir, Deputy Le Hegerat asked a question about whether someone could come to Jersey, live here for 2 years, and whether they could stand for election despite having not having entitled to work status in Jersey. And my answer to that, sir, is under the current law as it stands, without the amendment, is yes, it would be possible for that person to do that. And because under the current law, a person simply has to establish 2 years ordinary residence. They have to obviously have to have British nationality as well. So that person would be able to stand despite not having entitled work status or entitled status or license status. So that person could stand under the current version of the law, but under the proposed amendment, my answer is that no, that person would not be able to stand, because in addition to in addition to needing 5 years of ordinary residence, they would also have to have one of those 3 categories under the Control of Housing and Work regulations, namely licensed, entitled or entitled to work only status. So that person would not be able to stand under the proposed draft law as set out in this amendment. And so I would add that I would remind members that earlier, I think it was in March, members approved the migration policy in P137 of 2020, and under the migration policy which was just put to members in principle. It wasn't setting out any legislation, so the legislation is to follow. But under P137, members approved in principle the abolition of the entitled to work status. So if the proposition were to be adopted and thought would need to be given to whether there would be some sort of specific exception for membership of the states in relation to entitled to work persons, because those persons wouldn't be able to stand if the proposition was adopted, and the legislation that would follow on from the approval of the abolition of the entitled to work status didn't provide for some specific exception. So I hope that answers all members' questions.
Thank you very much, Mr. Attorney. Deputy Sutherland, you have a
question for the
question?
attorney.
Attorney, yes.
Thank you, sir. And it's about the extent to which the ordinary resident rules operate and what constitutes a gap in ordinary residence. The Attorney General appeared to be saying that for tax purposes, 1 year out of the intended 5 would disqualify you. And I'm wondering whether that 1 year out of 5 would also mean that ordinarily residents wouldn't apply to somebody trying to stand as a candidate because of the break, if they took a break of a year.
Attorney, are you able to assist?
Yes, sir. The deputy is correct. So if the person was away for more than a year from Jersey, then that would mean that they would not be able to stand under the proposed amended version of the law in this proposition. Under the current law, if the person was away for a year, they might still be able to qualify to stand for the states, because, as I said in my previous answers, the current law provides 2 alternatives as regards being ordinarily resident. Either the person has to have completed 2 years of continuous ordinary residence in Jersey, or the second alternative is that they complete 6 months up to the date of the election, but then they also have an overall total of 5 years of ordinary residence. So in the deputy's example, the person might qualify under that second alternative if they had the overall 5 years of ordinary residence, and then in the 6 months prior to the election they were also ordinarily resident in Jersey.
We appear to be digging a hole, that's all I can say.
Well,
thank you for the advice.
Thank you very much, Deputy. Deputy Swan, you also have a question for the attorney.
Thank you, sir. May I ask the attorney's opinion on a resident of Jersey who might be recruited into Her Majesty's Armed Forces and serve for a length of time exceeding 1 year and be living and establish a home in forces accommodation, there being no opportunity to serve in the forces locally. That person from Jersey necessarily has to reside away from the island. Would they be ineligible for election upon their return to the island to live? Thank you, sir.
Mr. Attorney, are you able to assist?
So yes, they might be able to stand for election under the second limb of ordinary residence under the current version of the law. So if the person could establish 6 months of ordinary residence up to the date of the election, and then an overall total of 5 years of ordinary residence in total, then that person might be able to stand for election, or be able to stand for election, provided they were a British national. Thanks, sir.
That will be under the current version of the law.
Under the current version of the law, yes.
And under the proposed amendments to the law?
Under the proposed amendment, no, because the proposed amendment is that they have to have been ordinarily resident in Jersey for at least 5 years up to and including the date of the election. So that's very clear. You have to have 5 years up to and including the date of the election. There is no alternative, as under the current law, of just 6 months up to the date of the election, provided that you also have an overall total of 5 years.
Thank you very much. Very well, that ends questions to the Attorney General, as presently notified. Next to speak is the Deputy of St Martin.
Thank you, sir. Sir, I wouldn't be so presumptuous to say that other states members made a mistake and didn't know what they were doing when they voted on the various votes in P75. The States Assembly made a decision, and that's why we're here today. But I do know, sir, that on reflection immediately after that debate, that I had made an error in the confusion on those various votes in that debate, one that I greatly regretted. I'm not in favour of greatly reducing the eligibility of people to stand for the States Assembly. I'm not necessarily, definitely not in favour of reducing the eligibility. I don't want to go as far as Deputy Tadyer proposed and allow almost anybody to stand, but I do believe that where we are at the moment with 2 years is probably about where we need to be. And I have decided that I will be changing my mind from the votes I made back on P75 2020 and be voting not to bring this in today. Thank you, sir.
Very much. Does any other member wish to speak on the principles? If no other member wishes to speak on the principles,
See two in the chat.
I've got Deputy Ward next, and then the Chief Minister after that.
Thank you, sir. I wanted to speak. I wanted to thank the Attorney General for the clarity of that answer, because I think for many of us who've been, I know last night on going home, I was looking through this and just thinking I should have asked the Attorney General a question, but they have been asked, which is great. And it is clear that we have a current law which, although perhaps needs overhaul and needs looking at, we made a change, or some voted for a change, which does not improve where we are, given the context of where this assembly is at the moment, and the context that we are looking forward in terms of encouraging candidates to stand, encouraging healthy, contested elections across the island, so that we drive up the governance of the island in terms of the quality of candidates who are here. I think someone has the speakers on. That better. I'll just let the deputy receive some IT assistance. There we go. Brilliant. So there were a couple of things that I was surprised at some of the comments. I think we need to be clear that if you leave the island, and it's clear now from the Attorney General, for a year, regardless of whether you were born here, whether you moved here, regardless of all those things, then this law means you have to stay here for 5 years before you can stand for election. Now, if you have lived vast proportion of your life here. You move away for a year for one of a myriad of reasons, be it work, be it to gain experience elsewhere. And we're always encouraging people to go and gain experience and bring that back to the island. Then what we're doing is then saying to those people, but by the way, you've got 5 years of some sort of proof before you can stand. Currently it's 2 years, and they are arbitrary times, and I'm not entirely sure why the 2 years are there, but that's for another time. But this makes a step backward. And in the end, I'm not entirely sure, and I did rack my brains to try and think, what is it that people do in those extra 3 years that make them more eligible or make them more appropriate to stand for election? And let's remember, it's about standing for election, not being elected. As many know, those are two very different things, because it is in the end the electorate who decides whether somebody comes and sits in this assembly to represent them. And you have to get your message across, and you have to convince the electorate. The reality is, if someone arrives on our island with no background, etc., it will be more difficult, because you have to get used to, and you have to have a reason for standing. And we all have our own individual reasons for standing, be it because of your experience on the island, of family's experience that you want to improve. I speak for myself there. We all have our own experience of why to stand, and they are very personal. Sometimes they're very collective when people work together as well. But we need to remember those, and this change does nothing, absolutely nothing to address that, or is totally irrelevant to that. The current law, it has the word "or" in it, and that's the key. This change has the word "and." And as we've seen before in this assembly, a single word can make a lot of difference to the implications of a piece of legislation. And that's certainly the case here. And I don't think we can equate the changing a decision on this with other decisions that came back to the assembly. I think they were very different, and there were very different reasons for people bringing back those debates. This one is something that's been recognised by a number of members immediately after debate, and by PPC. And can I make this point about the political nature of PPC? One, I would say we're all politicians, by the way. I just remind you all of that. You know, we are all elected politicians, and so to say that you're apolitical, I think, is not true at all. But in terms of PPC, it is from across the assembly, and anyone who has worked with scrutiny or PPC or PAC knows that you cannot be the lone voice on that. You have to take people with you, and you have to listen to other people. That's why it's good for us all to do scrutiny and be involved with scrutiny, because it means that we don't exist purely in our own echo chamber, and that's healthy for everybody in this assembly. So I would suggest that I'm a bit, I object to that. I don't think that is the case. I think that's incorrect. So by not addressing this change, by not voting for this, we will have the opportunity to correct something, to go back to where we were. And with the clarity that we've got through this debate, and it's very interesting that we begin on Wednesday morning all fresh after a night's sleep with some clarity from the Attorney General. And I know for one, I am absolutely certain about my voting today, absolutely certain that this is not the change that is good and healthy for this assembly. It's not a change that is healthy for this island, and it's not a change to attract those people that we want to, the diversity of this island, and get to that point which I think deep down we all want to be at, which is this assembly genuinely reflects the population of this island. And that's what we need to have if we are going to have healthy governance and a healthy democracy. I urge people to reject this legislation. Thank you, sir.
Thank you very much, Deputy Chief Minister.
Yes, sir. Quite pleased to follow the last speaker, sir. I was actually looking back at what Deputy Tadier, assuming I have got the right amendment, actually proposed. And he basically said, sir, in the amendment, that a person should have a continuous period of residence of 5 years and be entitled to work, etc., etc., to be eligible to stand for a basic election in those days as Centre Constable Deputy. And I think it was very clear, sir, that it was a continuous period of 5 years. And I think what we have to remember is we're not talking about, I don't know, somebody applying for a normal job. One is applying here, sir, to represent the island, represent the public in a legislature, and representing the island and its culture and its community, sometimes internationally. There are quite significant responsibilities that come with this role, even though the public may not always recognise those. And what was interesting, so I was going back two things. One was what I said previously in the debate of the day, and also, sir, what actually Deputy Taddio's arguments were on the day in support of his amendment. And so, as I said, we have to always recognise, even though, and remember, even though sometimes the media or certain sectors of the public may not realise it, it is an honour to represent the island in this assembly. It's hard work, we know that, but it is an absolute honour. And what I'd like to do, sir, is pick up on a couple of arguments that have been made. But what Deputy Taddeo said, that he in himself thought he was relaxed about the need for any length of residence or what that length should be. But he said, I've been convinced to take 2 points into account, which seem germane to the wider argument. And firstly, sir, the first is a technical argument. Jersey has a long-standing policy that most jobs require people to have been in Jersey for 5 years to be employed. Cited the public sector, and some have pointed out to me that it is inconsistent that no such rule exists for standing for the job of States member, and that actually is quite valid. The second point is that he makes the point that we are not the British Parliament, we are the Parliament for the bailiwick of Jersey, and it could be argued intelligently that to be a Jersey politician, you should simply have to be a Jersey citizen. He then actually carries on and say, for example, cites the role of a police officer. It says they do need to be a Jersey citizen, however, with 5 years residency. Obviously, part of it was around British nationality, but he does make that point, sir. And then, again, sir, the same would be the case for any successful candidate. After 5, who did not, in this case, is around nationality. After 5 years, they would be Jersey qualified. They would take the oath of office, and they would, amongst other things, make Jersey laws for Jersey residents. Now, the argument, of course, Deputy Taddeo was running as well is around British citizenship versus non-British citizenship and who should stand. But I find it slightly odd, sir, that the criteria for a British citizen should be any different for somebody who isn't a British citizen, and therefore, sir, harmonisation at 5 years, which is consistent with all our other roles, including that of a police officer, would seem to make sense. As I said, sir, the role of a States member, believe it or not, as in certain parts of the public will not agree with this or may not realise it, is actually an important one. It is representing the island in all sorts of circumstances, as we have seen in the last few days, and it is about implicitly understanding that culture and how we operate. And so it is not inconsistent with other jurisdictions. The one I particularly cite is, which was cited last time around as well, is the United States requires a member of the House to be at least 25 years old and have been a US citizen for at least 7 years. So, sir, it then comes down to working through, should we have a restriction as a time restriction or time threshold, or should we not? Because one could go for the argument, well, actually, we shouldn't have any restriction, in which case somebody can come into the island on day 1 and stand for election on day 2. I would hope most people would consider that ridiculous. But in which case, what is an appropriate level to have a restriction? 5 years would be consistent with a number of the other restrictions that we have in place. And so on that basis, sir, I think I'm going to keep my argument as short as I've got to, sir. I see no reason for changing my vote. I did understand broadly what we were voting for. I think the argument that Deputy Ward has just tried to run, that actually, yes, we should, in the same way as actually Deputy Morell very carefully reminded us yesterday. There was criticism in the last debate when on electoral reform of people challenging the in-principle decision that had been made prior to that. And I think that same argument runs today, sir. The Assembly agreed in principle to make this change. It was a well-argued debate, And I think, frankly, sir, we should be sticking to that decision. Otherwise, the alternative argument also falls, sir. So let's be consistent, and I will be voting for this proposition, sir, and supporting PPC. Thank you.
Very much, Chief Minister. Does any other member wish to speak on the principles? If no other member wishes to speak on the principles, Deputy Ash.
Hi, sir. Can you hear me there?
Yes.
Good. That's excellent. Well, I hope it's excellent. It depends whether people like what I'm going to have to say. I tend to greatly agree with what Deputy Morell said yesterday. This wasn't a mistake. It was a mistake on Deputy Tadier's part, I think, and he admitted it himself. He had bought this. He'd put that in the hope that by offering a 5-year FOP, that we would all agree to have non-British citizens sitting in the States. That was voted down, and he ended up with a 5-year situation on his hands as well, and thus we're now being asked to review it. Personally, I would like to see PPC withdraw that. I think there's still time for them to withdraw it, because I think we need to put considerably more around what this 5-year means. I personally think that if you were born here, that should be sufficient to stand. If you've left here, having been educated here and lived here for your whole life and joined the armed forces and worked away, then you should be eligible to stand. So I think we need to put a lot more wrapped round what constitutes 5 years. The other thing I thought that was very salient to this whole debate was made by Deputy Lahagarat yesterday. And I have a copy of the JEP here, sir, today. One of the skin clinic here is looking for a secretary receptionist, 15 hours a week. Successful applicant would need to be flexible. Probably rule me out at my age, but one of the things it says down at the bottom there is all applicants must possess entitled to work status. So you would have had to have been here for 5 years. So what we're effectively saying with our laws is that to work as a receptionist for a skincare company, you have to have been here for 5 years, to do that job for 15 hours a week. But to work the many hours a week as a state's member and make the laws of the island, you merely need to have been here for 2 years. And to me, so that does not make any sense at all. So one of those two things are wrong and need to be addressed. And that's why I feel that I would ask PPC, and I say it's not too late to withdraw this. Let's have a look at exactly how we phrase this 5 years and then bring it back more realistically. Thank you very much, sir.
Very much, Deputy. Does any other member wish to speak on the principles?
Oh, yes, please, sir.
We would normally do that.
I know, sorry.
Thomas St Martin.
It wouldn't,
No, that's sorry. Thomas St
sorry.
Martin, indeed.
I'd just like to say, from a perspective of being a Connaught, that to become a member of the Honorary Police, you only need 2 years continuous residency. And we're fortunate to have a diverse HP membership. And I, for one, am extremely proud of the Honorary Police in my parish, as I know all the other constables are. So surely if 2 years is long enough to police our lovely island, it's long enough to stand for election. And certain, we bring other people in. So, we can bring in a chief executive who's had no experience in the island whatsoever. And he's, he or she is allowed to hold a very prominent position. But we're saying to our own people, well, actually, you're not good enough unless you stay for 5 years. So I'm just saying, I just thought it was interesting to say that, yeah, if you want to be a member of the Honorary Police, you need 2 years residency. So thank you.
Deputy St Peter.
Thank you, sir. I myself, with Deputy Morell and the Chief Minister, insofar as the Assembly knowingly approved this in principle proposition whenever it was, and hence the purpose of the debates today. However, I'm struggling with a couple of things, and I'm really only jumping up metaphorically, so to speak, to support Deputy Ash, because I think we're so very nearly there, and I don't know why at some stage something has slipped through the net here, but between Deputy Tadier's proposition and then coming back to PPC, and I don't know what it is, because it's very interesting the amount of questions that have been raised by members, which implies that maybe, and I'm guilty of this as well, didn't give enough thought to this particular proposition in advance. And I actually think it could come back with absolutely the ideal, and I wish I'd thought about it and brought the amendment, and Deputy Ward raised it, the difference between the word and or. Because if there was and, I would not have been able to stand when I did in 2018, and if it was an or, I would be able to, and that is because I'm entitled to work, have entitled status because of previous tenure in the island and birthright, but mainly the previous tenure in the island. I've been brought up in this island, been brought up in Jersey. So I'm inclined to support if push comes to shove, but I really would like PPC to take into consideration Deputy Ash's words and my support of those words, and come back with just a tiny bit of fine tuning, which I think would be would really enhance it. Just that word and or, I think, would make all the difference. And I thank Deputy Ward for drawing that to our attention. Thank you, sir.
Thank you very much. Deputies, any other member wish to speak on the principles? Deputy Guida? I beg your pardon. Before you speak, Deputy Ward, do you have a question?
So yes, I don't know how to bounce this question, but procedurally, I don't believe that these regulations can be delayed and changed. So we may be talking about something that can't happen, and I think it's really important when we get to these points to have a ruling on that. I wonder if I can ask. Thank you, sir.
Well, the question is whether it is open to PPC to withdraw.
Yes.
The debate is open. PPC can withdraw with the leave of the Assembly.
Okay.
Yes, that was your question. Deputy Guida.
Sir, I can only talk about my own experience after having been elected in 2018. And I vividly remember having to go to Social Security to acquire a card that I'd never had before, having been self-employed in the island. And what they asked for was an entitled card. They wanted an entitled or entitled for work card. They were not going to go with a simple registered one, which would have been my standard situation. And this was actually quite difficult to obtain despite my many years in the island. So I do not think that today it is legal to have somebody in the Assembly who is not entitled to work. I cannot see how that is possible, and certainly Social Security was not going to let me get away with it, and I had to get my card. I wouldn't be in this Assembly. Thank you, sir.
Thank you very much, Deputy. Deputy Hegarrow.
Thank you, sir. I, like many, was confused the last time and did vote incorrectly. But more importantly as well, I would just like to make a point that I think it was the Chief Minister made in relation to the States of Jersey Police. They are actually, I think you'll find, able to be recruited as 3 years, having lived on the island, because a probationary officer would then do 2 years of probation, which would take them up to the 5 years. But I would also like to make the point, like the Constable of St Martin did, the ability to have been able to recruit police officers, as an example, from across the island and across the population has significantly made a difference to that service. Without a doubt, what they brought to the States of Jersey Police was significant, from the ability to be able to deal with our community across the board. And so therefore, I think that it is important that the States Assembly also represents the island population as a whole. So I will vote against this today, because I think it's the right thing to do. The questions I asked yesterday of the AG was to ensure that I was able to vote for something that was legally right, and the AG for me today has confirmed that this can happen, so I will vote against it. Thank you, sir.
Does any other member wish to speak on the principles? No other member wishes to speak on the principles. Senator Farmer.
Thank you, sir. I'll be quick. I'm not sure I subscribe to the confusion that members are claiming from the last debate. If the papers were read properly, it was very clear. The ramifications of the vote was very clear, and of course it's odd to hear propositions being brought in line with the state's decision, but not really being supported by the bringers of the proposition. I'm not being critical of PPC in any way, shape or form, but I remember being chastised myself on a number of occasions, not recently in the recent debate on electoral reform, where those of us that brought or considered amendments and tried to change the law after an in-principle state's decision had been made were heavily criticised. Yet it seems to be okay to do that in this instance, and I don't necessarily disagree with that, because I think these debates and the law is there to be changed when we want to and when we need to, and we can be faced with different facts or different opinions. I've always said I'm prepared to change my mind when faced with compelling new facts, and nothing wrong with that. This assembly is at the heart of island life. It's not the same as serving the island in many great ways, such as in the honorary or states police. Those roles and the roles of many like that are to enforce the laws and policies made by this assembly. The role of states members is to create policy and approve laws and debate appropriately. And I think it's really important that states members have a really good understanding of our island, of our culture, of the people. And it is true that this assembly needs to be representative of the people of Jersey. I think it's more representative than I've ever seen it, and it's certainly moving in the right direction. But we won't do ourselves, I don't think, any favours if we don't encourage people to show commitment to this island, proper commitment in this sort of transient world that we live in. Well, not recently with COVID, but I think post-COVID, people are going to want to travel and move. It's really, really important that the people that serve in the assembly understand the island, the cultures and the society they serve. Whether you can do that by being here 6 months or 2 years or 5 years is a matter for members to decide for themselves. The recent electoral reform has removed the island-wide mandate, and people will say, well, I think it has been made in an argument that you need to stand a chance of election. You need to have had a profile in this island. But I think the new electoral system will change that. That remains to be seen. So I think it's probably is important at this stage we stick with the decision that the state's made and support the proposition today. Thank you, sir.
Senator, does any other member wish to speak on the principles? Point of clarification, Senator Valois, from the previous speaker?
Yes, please, sir.
What is your point of clarification?
He made a point about commitment to the island. It didn't expand on that in particular. I'd just like him to clarify what he means by commitment to the island.
Are you prepared to clarify your meaning there?
Yes, absolutely, sir. And that is a fair question. I meant by length of residency, commitment to the island is moving to the island and putting some time in as a resident. So residency, sir. Thank you.
Very much indeed, Senator. Does any other member wish to speak on the principles? No other member wishes to speak? Then I close the debate and call upon Deputy Alves to respond.
Thank you, sir, and I thank members for their contributions and the Attorney General for the various clarifications he gave. I just wanted to address a couple of things that were raised yesterday by members. Senator Ferguson said that regarding people who only being here for 6 months and being able to stand straight away, this is incorrect. As the AG stated, candidates need under the current legislation, candidates need to have been resident for 6 months preceding the election, in addition to completing 5 years at any time for an additional period or periods totaling at least 5 years. Something else I also wanted to raise, and I thought was important to note, was something that the Deputy of St Peter briefly mentioned. This change could disqualify current members in this assembly from standing for re-election. Okay, for example, if a member were here for 6 months before standing for the election last time, the current requirements, if they stood again, they would not be able to if these changes were adopted, as they would fall short of completing the 5 years residency. Shortly after the debate on Deputy Tadier's proposition, the indication that I and others on PPC received from a number of members who voted in favour was that there had been some confusion and mistakes were made when voting, as members like Deputy Young, Higgins and Southern stated yesterday, and today we've heard the same from the Deputy of St Martin and Deputy Lehegaram. Deputy of St Peter's is asking for a point of clarification, sir.
Yes, Deputy St Peter's, point of clarification from the Chair of PPC.
Yes, can I just ask Deputy to clarify that point, because I think my point was I wouldn't have been able to stand in 2018, but I most certainly would be able to if I stood now, mainly because 4 years have elapsed, and even under the previous rules, I would have needed 6 months or 2 years in order to be able to stand. So I can't believe there's anybody who can't. So can she just clarify that point, that that's actually what she did mean to say? Because I don't believe that to be the case. Thank you, sir.
Well, are you able to clarify whether you were in fact saying that current members could not now stand?
I said it is possible that there are current members, not directly referring to the Deputy of St Peter, but it is possible if members had only just fulfilled that 6 months that they wouldn't be able to stand under this new change. Okay, so
please do carry on.
Thank you, sir. I have to say, sir, that I am appalled by some of the insinuations from some members yesterday that PPC is being political, or that I, as the chair, am using PPC as a vehicle to project my own political views. Just want to make it clear that nowhere in the report or the speech did I or PPC ask members to vote against this proposal. We have simply stated the facts about the proposal and the consequences of adopting this law. This law will significantly restrict the number of people eligible to stand for election. This is fact, not opinion or political view. And we have urged members to consider carefully the consequences of this change. I am the chair of a committee with a mixture of members on it. I would not have made the opening speech, and the report would not have been published without a majority agreement in the committee. And PPC would not be doing its job if it did not make clear to members the consequences of these proposals. The issues are clear, and although the committee were not unanimous in its support, it was unanimous for the need for us to bring this back as our duty to the Assembly. So to address Deputy Ash's contribution and a couple of others, it would not be appropriate to withdraw this now. Having a debate on policy position and the states fully supporting whether they knew or not what they were voting for gives members the opportunity to have a second go when legislation comes forward. It does not mean that just because a member may have voted for it in the first proposition that they have to vote for it in the legislation, as they may have changed their mind. This is democracy. The fact is, sir, that this proposal was not thought through in this context, as it was part of a deal to change the citizenship requirement. We think that the Assembly should express a view on this, and if it is a no and somebody would like to have another go at it, then they can do so. Otherwise, PPC will be left in a difficult position of doing work which it doesn't agree with, and with no clarity as to what that extra work will be. So as always, I'm in the hands of the Assembly and I maintain the principles and ask for the appel.
Thank you very much, Deputy. In which case I ask the greffier to put a link into the chat for voting. I open the voting and ask members to vote.
So at the present time, I can't get in. So is it all right to vote?
Would you like, if you can't get in, then please feel free to record your vote in the chat.
I can't even get into the chat at the moment.
Well, then, just before we close the voting, if you still haven't been able to get in, Deputy, I'll take your vote as expressed.
Thank you, sir.
In the Assembly.
Yes, I'm not able to get in either, sir. Sorry. I shall vote in the chat.
Very well, thank you. Very well. Any members either in the either online or in the Assembly who have not been able to register their votes, could those online please register them in the chat, and those in the Assembly indicate their vote now. Have you been able to vote, Deputy Trinity?
No, sir. So can I go contre?
Contre. Yes, record that as a contre. If members have had the opportunity of casting their votes, ask the greffier to close the voting. The principles have been defeated. 17 votes pour, 23 votes contre, no abstentions in the link, and a further 5 votes registered contre in the chat.
Could we have the scores on both sides, please, sir?
Yes.
Those who voted pour in the using the link were Deputy Wickenden, Senator Gorst, Senator Lapondre, Deputy of St Peter, Deputy Lewis, Deputy Gruville, Deputy Aye, Senator Farnham, Deputy Ash, Deputy Truscott, Constable of St Ballard, Constable of Trinity, Deputy Morrell, Senator Ferguson, Deputy Guida, the Constable of St Lawrence, and Deputy Pinnell. And those who voted contra were the Constable of Gruville, Deputy Alves, Deputy Ward, Deputy Dublé, Constable of St John, Deputy of St Martin, Senator Balward, Deputy Young, Deputy Labby, Deputy Martin, Senator Mezek, Deputy Lahegra, Constable of St Helier, Deputy Higgins, Constable of St Juan, Constable of St Martin, Constable of St Peter, Deputy Southern, Senator Pallett, Deputy of St Juan, Deputy Tadier, Deputy of St John, and Deputy Pamplin. And then in the chat we had votes contra from the Deputy of St Mary, Constable of St Mary, Senator Moore, and the Constable of St Saviour, and the Deputy of Trinity also voted contra.
Very well. Because the principles have been defeated, the proposition generally in the law draft is deemed to be withdrawn, and we move on to the next item of public business, which is the draft legislation Jersey Law P26, lodged by the Privileges and Procedures Committee. For the purpose of the debate, the main respondent will be the chair of the Corporate Services Scrutiny Panel, and I ask the greffier to read the citation.
Draft legislation Jersey Law 2000, a law to consolidate and supplement provisions about the making, commencement and repeal of legislation, to provide for the consolidation, revision and publication of legislation, to make provision about the Legislative Drafting Office, to amend and repeal certain other legislation, and for connected purposes. The states, subject to the sanction of Most Excellent Majesty and Council, have adopted the following law.
Deputy Alves.
Thank you, sir. So the draft legislation, Jersey law, may not immediately grab people around the chamber as the most important or exciting piece of legislation we have ever debated. It is legislation about legislation, but it underpins a fundamental feature of democracy, that every citizen should be able to know the law of the land, so that they do not unwittingly fall foul of it. They know how to benefit from it and they are protected by it. This law is primarily about access to the law, a fundamental right of the citizen that underpins the integrity of all other legislation that we pass. A right that echoes the demands of the Corn Riots enshrined in the Code of 1771, which we are celebrating this year. One complaint of the Corn Riots was that the Royal Court and the Lieutenant Bailiff were enacting laws without publishing them, so people could not know how to avoid breaking the law. The 1771 Code, for the first time, gathered together all legislation then in force into a single document and established this assembly as the law-making body for the island instead of the Royal Court. Fast forward to 2003 for the next major piece of legislation about legislation. The law revision Jersey law enabled our laws to be compiled with all current amendments added to the text or consolidated, which is the term normally used. In fact, that law went further. It set up a body called the Law Revision Board, which includes 2 members of this assembly. The board can make a limited number of changes to correct errors and improve the presentation of the statute book, such as renumbering, moving provisions around, and other improvements that stop short of changing the meaning of enacted legislation. In 2004, the first revised edition of the Laws of Jersey was produced using these powers. It was published both in print and on a website hosted by the Jersey Legal Information Board. The revised edition was updated once a year. That was a huge leap forward at the time. But now the gold standard is to make the law available as it is today, not as it was last year. Technology has moved on apace since then, and the Jersey Legal Information Board, JLIB website, is now where people go to find the current state of the law. For the past 2 years, a current law section of the website has presented a constantly updated version of the whole of the Jersey statute book. But at the moment, this section is not official in the way the revised edition was. If the Assembly passes this law, the current version will become official, so it can be cited and used in court. The legislation editor and her team in the Legislative Drafting Office work hard to prepare consolidations every time there is a change in the law. This change will enable the public and lawyers alike to use our legislation knowing that the version on the website reflects the current state of the law and can be used in court. This is a huge step forward in maintaining Jersey at the forefront internationally and offering up-to-date access to our legislation. Part 3 of the draft law underpins this consolidation work, but the law also makes other improvements. Currently, several different laws contain various provisions about making, amending, and repealing Jersey legislation. Part 2 of the law brings them together with a few additions and improvements. Part 4 is about the Legislative Drafting Office, the first time that name is used in legislation. It is no longer called the Law Draftsman's Office. The office does not belong to a law draftsman. It is an office of both lawyers specialising in drafting legislation and trained legislation editors. By the way, they are almost all women. It is not part of the Law Officers Department, but a distinct unit within the state's GREF. Its function is to serve all drafting needs, both for the government and for committees, scrutiny panels, and individual members. The new provisions impose obligations regarding the drafting, consolidation, and publication of legislation on the head of the office. That person is now titled the Principal Legislative Drafter. In recent weeks, the office has received some attention in the media concerning delays in bringing forward new legislation, something that has recently been confirmed was not due to any lack of drafting resources or resulting delays in drafting. There are many people involved in the process of turning policy into draft legislation that is fit to be brought to this assembly or signed by a minister. The drafting stage is just one part, though a hugely important part. This law rightly enshrines in statute the expectations and trust we place on the LOD in drafting legislation and making legislation readily available. I understand that moves may be afoot to restore the legislation programme so that members will be able to see the legislative priorities and the state of play of the various programme items. That should show whether any particular item is awaiting the preparation of drafting instructions, is being worked on by the drafter, or back with the department for review or to go out to consultation. In the interest of transparency, the Legislative Drafting Office is happy for its functions, its workload, and its performance to be subject to scrutiny. The drafters and editorial staff are proud of their achievements, particularly in drafting both for and during the pandemic. Indeed, without the current system of consolidating all legislation as soon as changes are made, it would not be possible for anyone to go onto the website and see the current COVID restrictions as they apply that day. With a number of these provisions attracting criminal penalties, this is not just an improvement, but an essential improvement. It is something that I will now be asking you to give legal authority to as the authentic version of the law. It is a rare thing for the Legislative Drafting Office to be drafting legislation about its own work, with the backing of PPC, of course. The principal legislative drafter asked me to state that this law was progressed only when other work was not delayed as a result. Sir, I commend this law to members and I propose the principles of the draft law.
Thank you, Deputy. Are the principles seconded?
Yes, sir.
Does any member wish to speak on the principles? No member wishes to speak on the principles. Deputy Morell.
Thank you, sir. And like many people, I would like to thank the law drafters for their hard work, and I'd also like to thank the Jersey Legal Information Board for the work they do in keeping the website updated. I find it invaluable. I do, however, have concerns, and it is not so much about it's not so much about the legislation, but as the practical implementation of that legislation. And so, and that is the issue with making the law as shown on the website official brings in issues of security. And should that website be changed by an external person, whilst that would be against the law, it would also pose problems for people who happen to be reading the law that had been hacked or amended by a third party maliciously. And also, maybe I haven't read the law closely enough, but the website itself places PDFs on the website as well as the HTML pages. And I'm not sure whether the law distinguishes as to which is the official version or not. This is one of the problems we have with something updated on a website, is that it then becomes prone to security issues. And we have that issue with Hansard and not knowing what the most recent document is, the most recent version is. And so I would really appreciate the chair of PPC helping me understand what security measures have been taken and will continue to be taken to ensure that any reader knows that that is an unhacked, entirely secure version of the law. And also if she could respond to, is it the PDF or is it the web page, which is the official version? That would be very helpful. Thank you, sir.
Very much, Deputy Senator Moore.
Thank you, sir. Simply wished to share with the Assembly today that the Corporate Services Scrutiny Panel has given some brief consideration to this law, and we were in favour and felt that it was a good sense of progress. That saying so, Sir, I have to say that we had not taken into account the thoughts of Deputy Morrell, and therefore I thank him for raising the point in relation to security, and look forward to hearing the response from the chair of PPC. Thank you, sir.
Very much. Does any other member wish to speak on the principles? Deputy St Mary.
Thank you, sir. I'm pleased. So I speak as a member of the Law Revision Board, which was elected shortly after I became a States member, and I just simply wish to note that that board is continuing its services. We have previously had, I think it's fair to say, annual meetings. It's not an onerous task to deal with the very small points set out in Schedule 1. It is a valuable service, and I think that last year, because of COVID, we may not have had that meeting, but following the passing of this law, which I'm sure it will be, I look forward to being summoned to go through the various alterations for our attention this year. Thank you, sir.
Thank you very much. Deputies, any other member wish to speak on the principles? Deputy Young.
Thank you, sir. I want to speak also in praise of this this proposal. I think the law officers, the drafting of laws is a crucial resource for the whole of government, and it's absolutely right that we can have consolidated versions of laws available to the public, because I certainly know that, for example, I during my time working in our sister island in Alderney, I had to refer to the Guernsey legal resource site constantly, and I thought, you know, where there are consolidated versions, and of course they have a more complicated situation because they have not just Guernsey, they have bailiwick legislation, they have Guernsey, they have Alderney, and they have Sark, and I think it really is a crucial resource. And of course this year, when we've had so many law changes on for example, COVID and others, and it's really difficult to try and keep track of where we are, and so otherwise it means a trail through all the various amendments trying to kind of work it out, and so I think this is a great move. I'm really pleased that we have the publication now and the restoration of the programme of legislation. I think there has, you know, I think our law officers have been fantastic, and I myself have made mistakes about, for example, I've at times felt that there was important, and you know, there are important laws that I sought to do, and it wasn't clear to me where the sort of key points were in the critical path that was determining the length of time to get these things done. And I think my comments were misinterpreted as under-resourcing in the law officers, and I've withdrawn that and made it clear that wasn't correct. But clearly there are so many other things that can happen. Drafting instructions are missing, drafting instructions are not quite right, law officers have queries that need to be resolved that require a political input, and then you've got the corporate side with all the machinations of what programs can go in the corporate plan and so on, which we've saddled ourselves with recent years, which is frankly I find an overhead we could do without. So I'm really pleased that we've got this this new arrangement to help clarify and members go forward, sir. So I've not owed favour of detail, but just to reassure Deputy Morrell, if one takes the Guernsey Legal Resource website as a model, they rely on PDF files, sir. I think what we have is the extra luxury of an HTML index version, but I mean, I think frankly, we might even have both, but I think I would have thought that's technically solvable, so thank you.
Very much, Deputy. Just to clarify for members, in case there is any confusion, and there may well not be, the Law Drafter's Office is not the same as the Law Officers Department. They are not connected. The Law Officers Department does not control the Law Drafter's Office. It's an independent office under the State's GREF. Just in case there was any confusion about that, I thought.
Sorry, sir. I accept the correction. I was loose in my terminology. Apologies for that, sir.
Very much indeed. Deputy St.
Thank you, sir. May I likewise commend all those who have worked in bringing forward this proposition, and indeed over recent years on the online resource that is available to us now. Having our legislation online and consolidated in this way has been a huge assistance to the courts, to lawyers, to us as states members, but I think more importantly to the public, because the laws that govern them, the laws that are made in this island are available, very accessible and comprehensible, and there is great help on the website explaining how to navigate the pages. And that is a huge advance. And I will remember, as you will, sir, as young lawyers before this online facility was available, trying to put together a consolidated version of a law that had been amended several times and ending up with several little bits of paper flapping about, trying to tape them into a master copy. Wholly unacceptable and difficult for all to work. So this has been a magnificent advance for the island and for all who need to work with the law. And Jersey is seen as a leading jurisdiction in this area of public engagement with its laws. And I believe other jurisdictions have sought advice from the Jersey Legal Information Board and have sought to emulate our excellent website and facilities we have here. So I will certainly support this proposition, sir, and with it thank PPC and all who have been involved in bringing forward our legislation in this way. Thank you.
Very much. Deputy Higgins.
Yes, thank you, sir. And I'll be brief, but I'm fully supportive of this law and the work of the Jersey Legal Information Board and the law drafters. A number of years ago, I brought a proposition to the States regarding laws that were in French being translated into English. And although I lost the proposition in the States, the former bailiff at the time instructed the Law Officers Department to provide an advocate who did unofficial translations and together with lawyers did come up with translations of the laws that are now on this website. And when I brought the proposition, the main point I was making was it was absolutely essential that the citizens of this island know what the law is. How can we hold people responsible for laws when they're not accessible to them? And this website and the translations has made that so. And it also makes us very much in compliance with the European Court on Human Rights, which has got substantial case law on this. So yes, I will support this. I wish they will continue to translate some of the legislations in French. There's still many of them that need revising, although I know that the main ones to do with criminal justice have now been done. And again, some of them we may have to look at whether some of these laws are really suitable in this day and age. I think if I remember correctly, the Code of 1771, for example, was talking about the mob and trying to deal with the mob attacking the magistrates. Anyway, sir, I'll leave it at that, but fully supportive of the proposition. Thank you.
Thank you, Deputy Wickenden.
Thank you, sir. Well, I am fortunate enough to, under one of my many hats, to sit on the Jersey Legal Information Board under your excellent chairmanship, sir. And I want to just say how hard-working all of the members of that committee are, and there's a lot of work coming forward that is about trying to make sure that everything is up to date on the website, that it's clear, that it's easy to navigate, and we're also doing some projects working on how to make sure children can have resources to find out what their rights are and laws are. So I just wanted to kind of stand up why we were dealing with this, because it is part of what Jersey Legal Information Board was about, and just and give my appreciation to the hard-working team that's on there, sir.
Thank you, Deputy. Does any other member wish to speak on the principles? No other member wishes to speak on the principles. Can I close the debate and call upon Deputy Alves to respond?
Thank you, sir, and I want to thank members for their contributions. Deputy Morrell raised a very good point, I think. The revised edition on the website is already the official version. The PDFs are actually generated from the HTML, so it's automatically updated when the HTML is updated. So they should always and will always be exactly the same. There was a question regarding cyber security and being hacked. So the current website is managed and run in the same way as the Government of Jersey servers. So the same security as the government services apply to this website. I think that was all the queries that
Thank you very much.
down. So thank you, sir. I'm maintaining the.
Thank you very much. Ask the greffier to put a vote into the link. The vote is on the principles of the legislation. Vote is there. I open the voting and ask members to vote. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. The principles have been adopted, 40 votes for, no votes contra, no abstentions in the link, and a further 2 votes for noted in the chat. Does your panel wish to call the matter in, Senator Moore?
No, thank you, sir.
Very much. How do you wish to propose the articles in second reading, Deputy?
Thank you, sir. So as explained, the draft law will bring together existing provisions and supplement them with additions and improvements. The law is divided into 5 parts. Part 1 is introductory. Part 2 covers how legislation is made, brought into force and repealed. Part 3 covers how legislation is consolidated, revised and published. It also introduces Schedule 1, which lists powers of revision. Part 4 covers the Legislative Drafting Office and the functions of the principal legislative drafter. And Part 5 contains the closing provisions and introduces Schedules 2 and 3, which amend other laws. So, sir, I intend to move each part with any schedule relevant to it on block, please.
Yes. So you're looking to move all of the articles on block together with the schedules?
So the parts, yeah. So,
do you wish to deal with part by part, or do you wish to deal with the entire articles?
Part by part, please.
Very well. So you wish to do part 1 and any schedule, well, there are no schedules associated with part 1. So is part 1 seconded? Any member wish to speak on the articles in part 1 of the draft legislation? That's simply Article 1 of the
that's right,
of the draft. No member wishes to speak. I close the debate and ask the greffier to post a link on part 1 into the chat. And I open the voting and ask members to vote. Members have had the opportunity of casting their votes. Then I ask the referee to close the voting. The articles in part one, the article in part one has been adopted. 40 votes pour, no votes contre, no abstention in the link, and a further 1 vote pour in the chat. You propose part two.
Yes, please, sir. So part two is titled Making, Amending and Repealing Jersey Legislation. And just to give some detail around each article. Article 2 describes how Jersey legislation is made. It continues to allow budget laws to be treated as laws before they receive royal assent. It allows the Assembly to make regulations to change the procedure for making subordinate legislation as future-proofing for new technology like electronic signatures. Article 3 covers how legislation is brought into force. It removes an existing problem with legislation coming into force retrospectively at the start of a day, even though it is not made until later that day. The article also adds an express power for the Assembly to allow regulations to be brought into force by order. Article 4 absorbs a provision from the Interpretation Law 1954 to prepare for a law coming into force. This article allows regulations and orders to be made, bodies established, people appointed, consultations held, and so on. Article 5 absorbs other provisions from the Interpretation Law. They deal with the effect of legislation being repealed or expiring. Article 6 is another provision from the Interpretation Law. It enables references to repealed legislation to be read as referring to the legislation as reenacted. Article 7 is a clarifying provision. It ensures that if a law amends subordinate legislation, then that subordinate legislation can still be amended afterwards by other subordinate legislation. Article 8 absorbs and clarifies the legislation amending power, Jersey Law 1999. It allows regulations to amend laws when there is an overlap between the lodging and making of two laws. Article 9 absorbs and improves more provisions from the Interpretation Law dealing with subordinate legislation. The improvements include ensuring repeals can be brought into force in stages. The article also avoids having to repeat powers to make incidental, supplemental, and consequential amendments. It also ensures subordinate legislation is treated as being made under all the available powers. Article 10 is new. It allows the Assembly to make regulations to enable subordinate legislation to incorporate documents of a technical nature which are accessible to the public. For example, this could include British or international safety standards, technical guidance on health and safety, construction and use of vehicles, shipping matters, or guidance on the use of pesticides. Article 11 absorbs and expands on the subordinate legislation Jersey Law of 1960. The Assembly can annul orders and other subordinate legislation not made by the Assembly, but currently there is no time limit on that power, which can cause unintended effects if the legislation has been amended or relied on in other legislation. This article sets a window for annulling the legislation, so it must be done in the next 3 sittings after the legislation is laid before the Assembly. After the window closes, a member unhappy with an order can still bring a proposition requesting the relevant minister to repeal it and make necessary amendments. I'd like to propose a vote en bloc for this, please, sir.
Yes, that's then is part 2, articles 2 to 11 seconded. And Deputy Young, you have a question for the Attorney General, and then you wish to speak.
Yes, sir. I think the proposer probably touched upon my question on Article 11. I wanted to have clarified or explained perhaps by the Attorney General that the legislation doesn't in any way prevent any member bringing forward a piece of a proposition to the States to annul an order which has been made by a minister, sir. I wonder if that could be just clarified, sir, because obviously I think that's an important provision, which my understanding is that I think that provision is still there. I'm not sure if it's made under standing orders or made under this law, but I would, if it's possible, to have that explained, either by the proposer or the Attorney General. That would be grateful, sir. Thank you.
I mean, the fact is, I think this is a procedural matter. Members can bring a proposition asking that the law be changed and annulled, and that the relevant minister bring draft legislation back before the Assembly. I don't see anything in this that would alter that, Deputy, if that assists you.
Well, no. So if I may come back, I think my view was that if when my understanding, in fact, when I sign ministerial orders, I'd always do so in the belief that members can challenge that subordinate legislation by bringing a proposition, which would then both hold that order back and in effect, and then allow the state's debate to either confirm or otherwise. That's my understanding. Maybe that was not correct, but that's what I was making, sir. Once the order has been made, the opportunity for members to put a proposition to set it aside.
And which article are you looking at in particular?
Well, I'll be frank, I'm not clear. I think it came under Article 11 because the proposer spoke about Jersey subordinate legislation, which is clearly the orders. I'm happy to leave that question, sir, for later if you wish, sir, if it's a problem.
Probably the attorney doesn't need this. Is it legal interpretation? Yeah, I think so. Well, you originally posed this as a question for the Attorney General. I thought it to be purely procedural, but it may not be purely procedural. So, Mr. Attorney, are you able to assist?
Sir, I believe so. Sir, I agree with your interpretation when you gave guidance concerning procedural matters. The power that I think the Deputy is questioning is the power in draft Article 11, the state's power to annul Jersey subordinate legislation not made by the states. And so Article 11.1 provides that if there is subordinate legislation, such as a ministerial order, then that must be laid before the states as soon as practical after it's made. That's in accordance with the current procedure under the subordinate legislation Jersey law, as things currently stand. But then what's different is that if after no later than 3 sittings of the Assembly after the date on which it's laid, then if the states resolve that it be annulled, then it ceases to have effect. So the difference is the inclusion of the reference to the 3 sittings of the states, which provide the opportunity for the states to recall that legislation and for it to cease to have effect if there's a resolution of the Assembly to that effect. But in my view, that with one qualification doesn't affect the ability of a member to ask for subordinate legislation, such as a ministerial order, to be debated by the States Assembly subsequently, because there's no clear rule against doing that. The one qualification that I would mention is in Article 11.3, which seems to me to be intended to exclude subordinate legislation which deals with the commencement of a piece of legislation such as a primary law. And if, for example, a ministerial order deals with commencement of that legislation, then it seems to me that Article 11.3 it excludes the ability for a member of the states to bring that ministerial order bringing into effect and commencing legislation after 3 sittings of the States Assembly have passed. And in my view, sir, that is appropriate and provides for certainty, because it would be unfortunate if perhaps years down the line, so a member of the states seeks to bring back a ministerial order which commences legislation, or commences the effect of bringing into effect the legislation years down the line, then that would be unfortunate. So I can quite see why that has been carved out from the current procedure by Article 11.3. So in summary, so the only difference to the current situation appears to me to be Article 11.3, which deals with the commencement of legislation. So I hope that assists.
Thank you.
Does that assist you, Deputy?
Thank you. Thank you for a very full answer. It really is very helpful. Could I just make sure I understood, please, correctly, 11.4? There is now a restriction that rescindment motion on an order has to be brought within 3 sittings of the state. Could I just check that at the moment there is no such provision that members can bring that? So this now means it has to be done within the 3 sittings.
Well, simply to comment upon the wording, this appears to me to simply say that to the extent that there's Jersey subordinate legislation that was made before the commencement of this part of the law, then when this law commences, any rescindment of it must be brought within 3 sittings.
Thank you, sir.
In other words, it's simply saying you take the 3 sittings as dating from the commencement of this law and not from the lodging of any subordinate legislation made before the commencement. Does that assist?
Oh, well, I think I've got it, sir. Thank you
very much. Did you wish to speak then, Deputy?
No, I'm going to leave it at that, sir. I think I've got clarification. My anxiety, why I raise it, is that I do think there is a case where I think historically there will be many. I think there will be old ministerial orders that potentially are out of date, and circumstances do arise when that's painfully obvious. And at the moment, my understanding was that members do have the right to bring that to the states if there is an order that is a problem, and have it varied. But it may be that that's no longer the case. I think in which case the ministers just have to be more on the ball at keeping the orders up to date. Thank you, sir.
I think there's nothing to prevent a member of the Assembly bringing a proposition to the Assembly asking the minister to change a current order. But that's not a rescindment of the current order. That's asking the minister to do it, and I think that can be brought at any time if it's out of date.
Thank you, sir, for that point. Thank you.
Does any other member wish to speak on part 2 of the legislation? Deputy Wickenden.
Thank you, sir. I think it's important to say that ministerial orders fall under the subordinate legislation Jersey Law 1960, which is a different law. And there still is the rules that set out that after any ministerial decision is publicised, so it has to be publicised online, that there is a 15-day period where it is no longer enacted, and to allow states members to bring in a proposition, and if they do bring in a proposition against that subordinate legislation, then that legislation gets halted even further until the debate has happened to see if it's been repealed. I think that's my understanding. Maybe Deputy Ells will be able to clarify that or not, but I'm pretty sure, just trying to help out, that that's what it is at the moment, sir.
Deputy Ward.
Thank you, sir. What I was going to just ask is, it's 3 sittings of the States Assembly for a rescindment, and I understand that. That's a very different period of time if we have 3-week sittings or 2-week sittings, particularly with breaks in the summer. And so it is, I just want to confirm it is the sitting. So is that the beginning of the sitting? And it may sound a little pedantic, but I think it's quite important if you ever do want to rescind something, because you can miss it. Is the sitting in terms of the beginning part of the sitting, i.e. when you constitute the sitting, and 3 sittings later on that point? Because I think it's just clarity for people in terms of the time span they have available if one does want to rescind a ministerial order. And I welcome the fact that I also hope that those ministerial orders are more transparent now because of this change, and I absolutely welcome that, because that is very much needed, rather than having to subscribe to an email to the Jersey Law Society every day and check them as I do. So just that detail, sir.
Well, I think 11.1 is I think tolerably clear, in as much as the any rescindment motion must be laid before the states as soon as practicable, and if the state sitting within 3 months deals with it. So the states effectively within if, for example, a rescindment motion was lodged within a week, then the states could annul it within 3 sittings.
Thank you, sir.
Very well. Does any other member wish to speak on this part of the articles in second reading? No other member wishes to speak? Then I close the debate and call upon Deputy Alves to respond.
Thank you, sir. So I'm just going to well, thank members for their contributions and the clarifications. Deputy Wickenden's comment about orders being delayed for 15 days. Currently, they come into force and then get annulled later. A minister responsible will normally not act on an order once there was a proposition for debate to annul it, but that is down to the minister concerned and is not always possible. I'm just going to provide a little bit of background around this article. So the Article 11 would incorporate an existing provision contained in the subordinate legislation, Jersey Law 1960, which requires secondary legislation not made by the states to be laid before the states, and enables the states to resolve that it be annulled. Judging by other jurisdictions, it is unusual for this power to be totally open-ended. So this article is slightly amended version on the current provision. It limits the window to annul the legislation to the next 3 sittings. So to have a provision enabling legislation to be annulled after it has been on the statute book for any number of years contrasts with, for example, the Westminster provision, whereby Parliament has only 40 sitting days to annul statutory instruments laid before it. Of course, as it's been stated already, if members are unhappy, they are still, with the provisions of an order, they are still able to, at a later date, bring forward a proposition inviting the relevant minister to repeal or amend it. So, thank you, sir.
Very much indeed. Ask the referee to put a voting link into the chat. Vote is on part 2. And open the voting and ask members to vote. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. Part 2 has been adopted, 40 votes pour, no votes contre, no abstentions in the link, and a further 3 votes pour in the chat. Do you propose part 3?
Yes, please, sir. So part 3 is entitled Consolidation, Revision and Publication of Legislation. I move it with Schedule 1. Article 12 introduces the various categories of legislation. As enacted legislation is the original text, including as it is first published. Consolidated legislation is a version in which all current amendments are incorporated to show the legislation as it is in force on a given date. Revised legislation, which I shall come on to in a moment, is a type of consolidated legislation. Article 13 requires the principal legislative drafter to produce consolidated versions. Article 14 sets out the editorial changes that can be made in consolidating legislation. They include the removal of commencement and spent provisions and the correction of obvious errors in typography such as grammar, spelling, punctuation, numbering, cross-referencing or alphabetical ordering. They also include correcting errors from previous consolidations and adjusting punctuation and formatting or other presentational features. This article strikes a balance in enabling minor and routine corrections to be made editorial while keeping proper checks and balances for significant changes to the text of legislation. The intent is to act with caution. It is fundamental that these changes are incapable of altering the legal effect of the legislation. The Legislative Drafting Office has been making these editorial changes in the unofficial consolidated versions for 2 years now and has not hit any problems. Article 15 continues the Law Revision Board, which was established under the Law Revision Law. Schedule 1 sets out powers available for the board to revise legislation. These powers are reproduced from the Law Revision Law. The changes made by a revision have effect as if made by amendment, and the minutes of the board must be laid before the states within 2 months. The board used to produce a full revised edition each year, 12 to 15 months in arrears, but Article 14 will mean that editorial consolidations can be made straight away and be treated as official. So the plan is generally to use the board's wider revision powers only on an ad hoc basis to revise individual pieces of legislation as and when needed. Article 16 requires the principal legislative drafter to publish legislation. As enacted, legislation must be published as soon as practicable after it is made. The last revised edition was to the 1st of January 2019, so consolidated legislation prepared after that date must also be published as soon as practicable. This removes the need for separate notice in the online Jersey Gazette. The Jersey Law website is a more obvious place to look for legislation changes with an option to subscribe to email updates. Article 17 achieves the aim I stated at the beginning of this debate, namely the creation of an official version of consolidated legislation. All as enacted legislation and an official version. Consolidated legislation is an official version if it contains a statement to that effect. In both cases, the official version must be from a website where it is displayed under the authority of the principal legislative drafter, or in a printed copy issued by or on behalf of the principal legislative drafter. An official version can be used in court and is taken to set out the legislation in its current form. If it is consolidated, then it is taken to be correct unless the contrary is shown. Article 18 provides the states to make statute law revision regulations. Those regulations can clarify ambiguities and reconcile inconsistencies to enable corrections to be made without need to use a law and obtain royal assent. No amendment may be lodged to a proposition containing the regulations if the bailiff considers that it would go beyond these powers. Other jurisdictions commonly use the statute law revision bills to make corrections to legislation. That is the inspiration for this new power. So in summary, sir, there are 3 levels of changes that may be made to legislation. The minor editorial changes under powers given to the principal legislative drafter, the continued law revision powers of the board, and the new power given to the states to make changes to the law to correct ambiguity or inconsistencies. Thank you, sir.
Very well. Are articles 12 to 18 and schedule 1 seconded?
Yes,
Yes, sir.
Does any member wish to speak on those articles or that schedule? No member wishes to speak. Then I ask the greffier to place a voting link into the chat. And I open the voting and ask members to vote. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. The part 3 has been adopted. 39 votes for, no votes contrary, no abstention. The link and a further vote for in the chat. Those part 4. Deputy.
Yes, please, sir. So part 4 is entitled Legislative Drafting Office. Article 19 continues the Law Drafter's Office as the Law Draftman's Office as the Legislative Drafting Office. The Law Draftsman is renamed as the Principal Legislative Drafter. The office is to have the objective of producing high quality legislation that can be easily understood and is readily accessible to all. The Principal Legislative Drafter is responsible to the greffier of the states for his or her functions, but not in relation to current drafting practice. A legislative drafter must have passed the assessments for barristers or solicitors in England and Wales that form part of the requirements for admittance as a Jersey advocate. Alternatively, he or she must have passed assessments that the principal legislative drafter considers are equivalent in Ireland or a Commonwealth country. The enshrining of current arrangements in legislation is not intended to remove flexibility, so the requirements can be amended by regulations. Article 20 sets out the functions of the principal legislative drafter. He or she is responsible for the drafting of all Jersey legislation, preparing consolidated and draft revised legislation, advising the greffier of the states on the drafting of standing orders, arranging the publication of legislation and of current drafting practice, and promoting access to legislation. The publication and access function is intended to lead to further refinements. An example is access to legislation on given dates in the past, which would be a useful tool for legal practitioners and other users of legislation. A recent amendment to the States of Jersey law passed by the Assembly means standing orders will no longer be treated as legislation. The greffier and his senior staff are experts in the operation of the standing orders. The Legislative Drafting Office will continue to make itself available to advise on their drafting instead of drafting them. Article 21 enables the principal legislative drafter to delegate his or her functions. There is a deputy head of the office to whom functions could be delegated to cover absences. Specific functions can be delegated as necessary, such as work of producing consolidated legislation and publishing it to the website. That naturally devolves onto the legislation editor. Article 22 gives legal professional privilege to confidential communication between a drafter and a person providing instructions. This gives the same protection from disclosure as for legal advice. It also covers drafts of legislation. It applies to states members using the services of the Legislative Drafting Office in the same way as to policy officials in departments. Article 23 enables the Assembly to amend Part 4 by regulation. We consider this provision necessary to allow for future changes in the structure, reporting lines and functions of the Legislative Drafting Office. Thank you, sir.
Very much indeed. That part of the law, is it seconded? Does any member wish to speak on this part 4 of the law? No member wishes to speak. Then I close any debate and invite the greffier to place a vote into the link. I open the voting and ask members to vote. I beg your pardon? If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. Part 4 of the legislation has been adopted in second reading. 40 votes for, no votes contrary, no abstentions in the link, and a further 3 votes for noted in the chat. Do you move part 5?
Yes, please, sir. So part 5 is entitled Closing Provisions, and I'd like to move it with Schedules 2 and 3. This part contains Articles 24 and 25, which just introduce Schedules 2 and 3. I have already described Schedule 1 in connection with Part 3 for the powers to revise legislation. Part 5 also contains Article 26, which gives the name of this law. Article 26 also enables the Assembly to bring the law into force by passing an act to specify a day, which will be when the Jersey Law website is ready to go live with consolidated legislation labelled as official. Schedule 2 contains consequential and miscellaneous amendments to other Jersey legislation. These changes include updating a provision that gave the Assembly copyright in Jersey legislation. There are changes to the interpretation law. Some delete provisions that have been moved into the new draft law. One change inserts a new provision which can be used for powers to appoint people. It would save repeating provisions about terms of appointment, about removal, suspension, reappointment, reinstatement, and about vacancy, absence, or incapacity. It is based on recent Scottish and New Zealand legislation. Any particular law can still make any different provision if that is wanted. Changes to other laws include deleting provisions that are no longer considered to be needed, such as the requirement to publish in the Jersey Gazette. Some reflect the change of title of the principal legislative drafter. There are also various changes to the States of Jersey Law 2005 relating to how ministers are given new titles and how functions are transferred between them. The largest changes are to avoid having to repeat the effects of the transfer in each transfer of functions order. Another change clarifies that the Chief Minister must present a written report 14 days before making a transfer of functions order. The Chief Minister is also given a time-limited power to tidy up the statute book by consolidating previous transfer regulations and order. Schedule 3 contains repeals and some consequential amendments following these repeals. Four old French laws are repealed because they do not have any practical effect in Jersey today. The other repeals are of laws which are replaced by this new law. Thank you, sir.
Indeed. Is the part 5 seconded?
Yes, sir.
Does any member wish to speak on part 5 of the legislation? No member wishes to speak. Then I close any debate and ask the greffier to post a voting link into the chat. Open the voting and ask members to vote. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. And part 5 has been adopted, 40 votes for, no votes contra, no abstentions in the link, and a further 3 votes for in the chat. Do you propose the legislation in third reading?
Yes, please, sir. And before I ask the Assembly to adopt the draft law in third reading, I would like to extend my thanks to members for their support and contributions during the debate. The Legislative Drafting Office also asked me to thank the Attorney General and the members of Civil Division of the Law Drafters Office for their assistance at various stages, as well as thanking members of the Jersey Legal Information Board who encouraged the development of this law. In turn, I would like to thank the various members of the Legislative Drafting Office, past and present, who helped shape the detail of this law. They have shown a determination to better serve the public by pushing hard to make up-to-date legislation available and to enshrine a duty to do so in this law. 250 years after the Code of 1771, we are taking to a whole new level the desires of those who first pressed for reforms in relation to access to the law. So, sir, I move the draft law in third reading. Thank you.
Thank you very much, Deputy. Is the law seconded for third reading?
Yes, sir.
Does any member wish to speak in third reading? Deputy Young.
So I think it would be remiss if we didn't thank the chairman of PPC, because I think what this is a very complex subject. We've had explained to us very comprehensively and thoroughly and very efficiently this law. So I would like to record my thanks for there, because I certainly think this is a very important law, and I think we've done it justice today. Thank you, sir.
Does any other member wish to speak in third reading? No other member wishes to speak. And I close the debate and call upon Deputy Alves to respond.
Thank you, sir, and thank you to Deputy Young as well. It is a very complex piece of legislation, and I hope I've made it more accessible to members. So I maintain the law. Thank you, sir. Can I ask for the appel, please?
Indeed, I ask the Deputy to place a voting link into the chat. I open the voting and ask members to vote.
Sir, can I record my vote verbally because my screen has just gone blank?
Certainly, Conatable. You could record your vote now if you wish. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. And the law has been adopted in third reading, 37 votes pour, no votes contre, no abstentions in the link, and a further 4 votes noted pour in either the chat or delivered within the assembly. Very well. The next item is pedestrian priority in Broad Street, St Helier, P28, lodged by the Conatable St Helier. There are 2 amendments, the first lodged by Deputy Gardner and the second by the Minister for Infrastructure. Conatable, are you able to indicate whether you're prepared to accept the amendments? I think if you accept the amendment of Deputy Gardner and the amendment of the Minister, Part C, I think, of the Minister's amendment would fall away automatically. Do you have a view on this, Conatable?
Yeah, I would like to accept both amendments. Thank you, sir.
Thank you for that indication. The proposition can be read as amended in that way, unless members object. And I would, well, I see there's a point of order from Deputy Lewis. So, Deputy Lewis. Yes.
Yes, thank you, sir. You picked me to the post, sir. There is also, I've been alerted to a potential conflict of interest regarding Part 3, Paragraph C of my amendment, and that of page 3, italics 1 and 2 of Deputy Gardner's. But I'll be guided by you, sir.
What are you concerned about?
Well, there is a direct conflict of the two.
Which is the part in your amendment that you wish to, you're referring me to, Minister?
Page 2, page 3, sorry, paragraph C, for the words pedestrian priority subject, the word sustainable transport corridor.
Yes, I think if there's an adoption of Deputy Gardner's proposition, then automatically that amendment of yours falls away.
But if the council was accepting both, then that cascades.
Well, I think all I can do is give you an interpretation that obviously we can vote on these things separately, or they can be read together. If they're to be read together, I think that would amount to you accepting that it would not be read with your paragraph 3 of your amendment. In other words, you would be agreeing not to proceed with that part of the amendment. But it's entirely a matter for you whether you wish to argue for it, in which case we will take the vote separately in the normal way.
Obliged, sir.
But I think you will probably, if we're going to read it, if members agree it be read as amended, then that would be the consequence, and it's a matter for you, I think, to indicate now whether that's something you would accept, so members know what they wish to do.
I would like to promote C in my amendment, sir.
So you would like to keep C going? Well, in which case I think probably we would deal firstly with, we could probably read the matter as amended by Deputy
Gardner.
Oh, yes. Oh, yes. Well, I think in which case we must deal with both sets of amendments separately. No, I think, well, in the circumstances, Minister, if you wish to proceed with paragraph 3, which you are entirely entitled to do, the Conitab has indicated he would accept both amendments, but we will have to deal with them separately as we go in the normal way. Very well. Then I would ask the greffier to read the proposition in its unamended form.
States are asked to decide whether of opinion to request the Minister for Infrastructure to maintain the current pedestrian priority restrictions in Broad Street, St Helier for the remainder of 2021. B, to work with the parish of St Helier and other interested parties to facilitate and enable initiatives and enhance the appeal and the vibrancy of the pedestrian priority area, subject to any public health restrictions for shoppers, workers, visitors to St Helier and residents. C, to review and where necessary, take the necessary steps to improve 1, the availability of on-street parking for disabled drivers in the central town area, 2, cycling access to Broad Street and within the pedestrian priority area, 3, bus services to and from the pedestrian priority area, and 4, service and delivery access to business premises in the pedestrian priority area. D, to monitor the operation of the scheme and to work with the parish of St Helier to carry out public consultation on its operation. And E, to report back to the states on the success otherwise of the scheme by the end of 2021.
Conitab.
Thank you, sir. This proposition has almost been invited by the minister, as I explain in my report accompanying the proposition, when in answering questions in the States, he said that he intended to reopen Broad Street to its former function unless a member of the States brought a proposition for debate. So that's what I've done. And I must say that I've been lobbied on both sides of the debate since then. Initially by members of the public who were so enamoured of the newly created pedestrian priority area after 11 o'clock in the town centre. They thought it was a pity that it was life was reverting to normal afterwards. But in fairness, I've also been I've met with the Chamber of Commerce, who are opposed to the project and would like to see more data gathering done first. I've met retailers and hospitality industry owners in the area who are very much for the project, but also others who are against it. So it is a matter which has divided opinion in the island, and I accept that. And it is a matter of the states, I think, coming to a balance between the opposing views. What I would say to members who are concerned about the proposition is that it's important to emphasise that it is just a trial. It is to see how things go for the remainder of this year and monitor the effects and to report back to the Assembly. And that I think is important to note, because it is not it's not casting it. It's not going to be set in stone. It is going to be a trial. So I'm picking up a bit of background chatter. I don't know whether I should stop and search it.
I'm sorry. It could be that I'm afraid you've been listening to me talk a little bit in the background on procedural matters. I apologise, Conitab. Please do continue.
No, I'm sorry, sir. I should have just carried on. I think I can probably do no better than just quote a paragraph from my report, just to refresh members' memories towards the beginning, where I talk about the opportunity we're presented to build back better in Broad Street, which is a phrase that's been used by many local authorities really across the world as they've been tackling the pandemic. All kinds of changes to streets, from large cities like Edinburgh to small towns like St Helier, have been made as a result of the pandemic. And people have realised that some of the changes that have been made because of the pandemic have actually made the towns and cities better places to move around. And that's why I've urged in my report, and I quote, the government to seize the opportunity to build back better in Broad Street, given that this proposal is consistent with state strategic policies, including successive island plans, transport policies, environmental, health and sports strategies for more than 2 decades. The work that was carried out around the Le Sueur monument at the turn of the millennium, restoring the fountains and lights and creating a new square at the top end of the street, has more recently been complemented by the paving of Sand Street and improvements to Charing Cross in recent times. These have led to a burgeoning in retail and hospitality activity in that area, and with plans now passed to introduce a water feature into La Croix de la Reine, there is no doubt that we are on the cusp of realising a major improvement to St Helier's public realm. No one who visits the excellent new Santander Work Cafe in the former Thomas Cook building and looks past the seating and the crapo on its plinth can fail to be struck by the opportunities offered by a second pedestrian priority route in the heart of town, opportunities that will be lost if Charing Cross is once again bisected by nose-to-tail traffic belching fumes as drivers seek an alternative to the congested ring road. And I end the quote there. The reference to the new cafe in my report is deliberate because it was in that cafe when I was discussing this year, the 60th anniversary of the Association of Jersey Architects, that local architects implored me to do something to keep the road in its present state. And anyone who's sat there, as I say in my report, or who's walked around Charing Cross will have been struck by how pleasant it is. And indeed, I've been lobbied quite hard by people who really want this current situation to continue, and they don't want to see a return to diesel buses coming down Broad Street. And in accepting the Minister's amendment, I'm very mindful of the fact that many people wishing to access the town centre by bus have had to walk from the bus station down Conway Street, and that is actually quite a long walk if you are mobility impaired. And I think the opportunity to bring buses into the heart of town, particularly if we have the new hopper bus that is being promoted by the Minister, and particularly if it is an electric bus fleet that we have in a number of years, I think that will actually complement the heart of town. It will certainly bring customers into town and set the cash tills ringing. And that, of course, is an extremely important thing for us to be doing as we come out of a pandemic. So it is a compromise, and I apologise to those states members, and I know there are several who would rather that I resisted the Minister's amendment. But my view is that, as I said at the start, this is a trial. Let's see how it works with the buses coming through Broad Street, mindful of the fact that we won't have all the other traffic that formerly was using Broad Street as a convenient shortcut to avoid the ring road. And indeed, as I point out in my report, until relatively recently, transport engineers up at South Hill referred to Broad Street as the inner ring road, which I think says it all in terms of how it was being viewed, not as a way of bringing life to town, but as a shortcut through our town centre. So I do urge members to give this trial a chance so that we can monitor its success. Members who are concerned about the activity of cyclists will note in my proposition that I have asked the Minister to tackle and to manage the cycle flows in the street. I do have concerns about unrestricted cycling when the street is busy. I think it is going to lead to conflicts, as indeed it would if it happened in the precinct. And I would gently remind the Minister that we are still waiting for a cycling strategy, which would make opportunities for safe and responsible cycling around and through the town much clearer for all parties. So, sir, I do propose the proposition, and I look forward to asking members questions afterwards. Thank you, sir.
Very much. Conattab, is the proposition seconded?
Yes, sir.
Now, we come on to consider the amendments. It appears to me that the correct amendment to take first is that of the Minister, because it amends the earlier paragraphs of the main proposition, as well as bringing in amendment to paragraph C. I think, though, what I should explain to members that if members vote to adopt paragraph C, paragraph number 3, which deals with paragraph C of the Minister's amendment, then the Assembly would have indicated what the form of paragraph C should be, and therefore I think Deputy Gardner's proposition with regard to a different paragraph C falls away. In other words, members at this point will need to consider whether Deputy Gardner's paragraph C is the one that is to be preferred, or the Minister's paragraph C is the one that is to be preferred, or indeed if neither of them are to be preferred. Because I think once the States indicates that they wish paragraph C to be in that form, the form proposed by the Minister, it is difficult immediately then for the States to vote on paragraph C being in a different form.
Sir, point of clarification.
Yes?
My amendment was submitted. My amendment. Not sure what's happening.
You had additional paragraph D.
Additional paragraph D. So what's happening with the paragraph D on the amendment?
Sorry, sir, I missed the beginning of her.
Apologies. My amendment has been submitted prior to the Minister's amendment. I have submitted it within a week after, or 2 weeks after lodging the original proposition, and I have paragraph D. So what's happening with my paragraph D?
Well, the first point to answer is that the Minister's amendment deals with earlier parts of the proposition, and one normally takes amendments to earlier parts of the proposition first. With regard to your second question, Deputy, it seems that that is put forward as a single amendment, and therefore that single amendment rises or falls. So members at this point will wish to make a decision whether or not they prefer your version or the Minister's version, or indeed no version of it at all, because they are not compelled to accept anything. But I wanted to make it clear that if the Minister's version is adopted, because these are all now being taken separately, it seems to me that any other amendment to paragraph C, which is in the slightest bit at odds with it, must fall away. So it's a question that you can speak to the relative merits in connection with this debate as well.
Thank you.
Very well. Then I ask the greffier to read the Minister's amendment.
1, page 2, paragraph A, for the words "to maintain the current pedestrian priority restrictions," substitute the words "to maintain traffic restrictions to support the principles of pedestrian priority and through access by bicycle." 2, page 2, paragraph B, for the words "pedestrian priority," substitute the words "pedestrian area and support the commercial centre of town centre through the creation of a sustainable transport corridor." 3, page 3, paragraph C, for the words "pedestrian priority," substitute the words "sustainable transport corridor." Delete subparagraphs 2 and 3 and renumber the remaining subparagraph accordingly.
Minister.
Thank you, sir. Firstly, sir, I'd like to thank the Constable St Helier for accepting my amendment to his proposition. If the Constable's proposition is accepted, a sustainable transport corridor will allow public transport to traverse the pedestrian priority area in the centre of town, obviously at a greatly reduced speed. This will ensure that those with reduced mobility who choose to travel by bus have continued access to both Broad Street and King Street. And a sustainable transport corridor will support commitments made by this government to promote active travel. So before we consider requests made in this proposition, I should remind members of the following. I closed Broad Street temporarily in response to the pandemic and have been clear throughout I would reopen the road once the restrictions on physical distancing were lifted. I would have lifted the current restrictions had it not been for Part A of the Constable's proposition, which requests me to extend the current pedestrian priority to Broad Street to the end of the year. But so if the Constable's proposition is unsuccessful, I will be compelled to reopen Broad Street. Returning to Part A of the proposition, I urge members to consider pedestrian priority as a shared space where different forms of transport exist and where pedestrians have priority but not sole use of. Preventing vehicles from entering Broad Street altogether is not practical. In the sense we will need access for emergency vehicles, etc. Part C asked me to review and where necessary take steps to improve the availability of on-street parking for disabled drivers in the central town area and for servicing and delivery access to business premises. Regarding availability of on-street disabled parking, I can confirm that alternative bays were provided to offset the loss of spaces in Broad Street during the temporary closure. I remain committed to providing improved access for islanders with disabilities, and I therefore work with the parish to review the alternative disabled parking requested by both the Constable's proposition and in accordance with Deputy Gardner's amendment. I will commit to review the need for additional on-street disabled parking in this area. In relation to servicing and delivery access to business premises on Broad Street, according to Geropedia, Broad Street, formerly La Grande Rue, was for a long time St Helier's principal road leading from the edge of town at the Charing Cross to the Royal Square. Whilst it may no longer be our principal road, it remains an important access route for the centre of St Helier. For example, Broad Street provides vehicle access for deliveries to the adjacent King Street, which is already tightly controlled. So adding similar controls on Broad Street will impact businesses in King Street. This is just one example of why we cannot consider Broad Street in isolation, and we must instead view Broad Street as a small but important part of a much larger and very complex transport network. Public consultation will be essential to assess the impact of the proposed changes to the transport network, and I would fully support Part D, which requests the Infrastructure Department to monitor the operation of the scheme and to work with the parish of St Helier to carry out further public consultation on its operation. However, sir, I will point out to members that in committing to further public consultation relating to Broad Street, the Infrastructure Department may need to prioritise other work to achieve this. Finally, sir, E asked me to report back to the States on the success or otherwise of the scheme by the end of 2021. If the Constable's proposition is accepted, I will be pleased to return to the States Assembly and update members on the outcome of the scheme by the end of this year. I make the amendment. Thanks, sir.
Is the amendment seconded? Minister, it might help were you to indicate, would you be prepared to agree to have these various paragraphs taken separately when it comes to the vote?
Indeed, sir.
Very well. And point of clarification, Deputy Higgins.
So I think I had one too.
Oh, I beg your pardon. Deputy Ward is a point of clarification first. Deputy Ward.
Thank you, sir. The Minister in his speech said that his amendment has been accepted by the Constable. We have had, nothing is being accepted. We will be looking at each amendment separately. The Constable of St Helier did say he would accept Deputy Gardner's, which is now not accepted, it seems, because it cannot be. I'm just very confused as to what we are actually looking at in terms of, we are looking at this amendment, which has been accepted by the Constable, but Deputy Gardner's has not been accepted by the Constable. I'm just absolutely confused as to what we're debating at the moment. And if I sit alone in that confusion, then I apologise to the Assembly. I sense that I'm not alone in that confusion. Thank you, sir.
Well, I think the position, Deputy, is this. The Connétable at the beginning indicated that he would accept both sets of amendments from both the Minister and from Deputy Gardner. The consequence of that, of accepting Deputy Gardner's amendment in full, is inconsistent with accepting the Minister's amendment to Part C. Consequently, had the Minister been prepared not to move his amendment to Part C, then the matter could have been taken as a single question and the proposition read as amended by Deputy Gardner's amendment and by the Minister's amendments, part 1 and 2. But because the Minister elected to put forward, as he's perfectly entitled to do, his argument that his version of Part C should prevail, then members now need to consider which version of Part C, and indeed which parts of any amendments they wish to see adopted. It's an unfortunate but perfectly procedurally correct, in my judgment, consequence of where we are. Whilst the debate is going on, I will give some further consideration to see if my view is in any way malleable, but at the moment I think that the analysis I've given members is the correct analysis.
Thank you.
Very well. So does any member wish to speak? Oh, I beg your pardon, there are other points of clarification. Deputy Higgins.
So my point of clarification is on the Minister's speech, but if Deputy Gardner's is on procedure, perhaps we should hear her point of clarification first, and then we can address the Minister's speech.
Deputy Gardner, is yours on clarification or of the Minister's speech?
Yes, sir, of the procedure.
Very well. Would you like to ask for your point of clarification first then?
Yes, follow your explanations. Does it mean if the paragraph C of the Minister's amendment will be defeated, we will move to the debate to debate my amendment?
Yes.
And in this case,
paragraph C, and the Minister has agreed to take the paragraph separately, so members will have the opportunity of voting on paragraph C. If they accept the Minister's paragraph C, your paragraph C will not fall to be debated. If they reject the Minister's paragraph C, then your amendment will fall to be debated.
Thank you.
Well, Deputy Higgins, a point of clarification from the Minister, I think.
Yes, sir. The Minister, in his speech, mentioned that if we go ahead with the proposal and there is increased consultation, it's going to be at the expense of other items his department is doing. Now, as I have proposals for the inner road, which have been going on for years, and Deputy Gardner's got other propositions for areas within St Helier, can we know what is going to be affected? Because it may well influence our decision on voting. Thank you, sir.
Are you able to clarify that, Minister?
Not entirely, sir, but I just have limited resources and due to COVID, a limited budget. So we will have to juggle things around, but I'm sure that can be done, sir. If I may say, sir, that regarding paragraph C, the only difference between my C and Deputy Gardner's is that Deputy Gardner's wants to go to Broad Street, as where with the bus and the hopper, I want to go through Broad Street. It's semantics, but it's the key to the whole thing as far as I'm concerned.
Or if I may just take a moment, if I may just take a moment to consider that, please, Minister.
Sure.
Well, I'm not sure your paragraph C says anything about cycle access at all, does it, Minister? Your paragraph C relates to something different within the proposition. It's your paragraph A that talks about through access by bicycle Broad Street. That is not in the slightest bit. It's where, but what you have. So there is no conflict in your paragraph C in that sense, and Deputy Gardner's paragraph C, insofar as it relates to bicycles. One is through access and one is to Broad Street.
Yes, indeed, sir.
So in maintaining your paragraph C, which you are entirely entitled to do, that has nothing to do, it seems to me, with cycle access.
And not in itself, sir. No.
There. Very well. Another point of clarification, Deputy Gardner. From the Minister or from me?
From you, sir.
Right.
I'm looking through the C and D. I know it's become too complicated, but like you mentioned, my C and my D are different. So if even if Minister amendment on C will be accepted, again, I'm asking, can we debate my D or it's come together?
Well, I'm going to give that further consideration. My
Thank you.
first view is that they are taken together because it's a single amendment, but I'm going to reflect a little bit on that before I make a definitive judgment on it. Very well. The Connétable, I think, of St Helier wished to speak.
Yes, thank you, sir. It certainly would have been simpler if the minister had accepted my olive branch to accept both amendments. As I read paragraph C in the two amendments, they're both doing very similar things. And of course, my proposition is crystal clear, and there is no ambiguity in any of its parts. The key point to make, perhaps, is that Deputy Gardner's amendment was made to mine to try to introduce a target date, and that she does that in paragraph D. Her other provisions are very similar to what I've requested in terms of doing a survey to try and increase disabled parking and matters such as that. So I think the key problem arose when the minister's amendment appeared, because as he rightly said in his speech, he is seeking to take buses down Broad Street itself. And both my original proposition and Deputy Gardner's amendment were based on the assumption that you could still service Broad Street by buses without having to take them down its length. You could bring buses to the Le Sueur Monument at the top end of the street, and you could bring buses down to Sand Street at the bottom end of the street, or indeed to York Street by the Town Hall. So that is how this happened. Myself and Deputy Gardner were working on the basis that buses would not be coming down the street. The minister has introduced the buses. And as I said in my opening remarks, I think that is something that is worth trying out for the remainder of this year. I also wanted to endorse what the minister is saying about disabled parking. It is absolutely vital that we find more spaces, but at the same time, I would say what I've said to many members of the public who've got in touch with me about these spaces, and they're very fond of them. There are 4 of them, and who knows how many vehicles come down Broad Street hoping to use them and are unable to do so. I spoke to one person who I asked them, what do you do when the spaces in Broad Street are busy? And they say, well, we drive around town until we find somewhere. Now that really isn't, although I understand it, that really isn't going to help congestion in town if we have hundreds of people driving around searching for a relatively short number of on-street disabled parking spaces. Much better that we find more spaces in our car parks and that we put more resources into the shop mobility scheme if they require it, so that people who are disabled have lots of options, including, of course, a better bus service, so that they don't have to take their car at all if they don't choose to. So as I say, sir, the other point I wanted to make about the minister's amendment is that I think it very usefully introduces the concept of a sustainable transport corridor. I think that's a good phrase, and it does help us bear in mind that we are in a climate emergency. That hasn't been mentioned yet. I was going to keep it to my summing up, but anybody who's watched recently the documentaries, particularly the Greta Thunberg documentaries on the BBC, can't have helped to have been struck by the fact that we are in a climate crisis. It's affecting all parts of the world, and we really have to act. And I think if this proposition, whether it's amended or not, is not approved, it will send out a very, very bad message in terms of Jersey's ability to take climate change seriously. So, sir, having said that, I am pleased to work with the minister. And just to pick up Deputy Higgins's point, if the minister is short of people to carry out the necessary monitoring and consultation, I'm sure that in the parish we can help him with some resources so that other work that's being carried out needn't suffer as a result. Thank you, sir.
Thank you very much, Connétable. Senator Farnham.
Thank you, sir. There's absolutely no doubt that the pandemic has changed things commerce generally, and I don't think that our town centre will be the same for quite some time for many retailers, and that's not necessarily a bad thing, because retailers have learnt to adapt and have adapted well and restructure to ensure they are, fit and in good shape for the future. Well, as best shape as possible, given the huge challenges they've had to face. And St Helier, the town centre especially, as do other areas of retail in Jersey, need to become more of a destination, more of an attraction to attract the footfall that's going to be required to sustain the business offerings we have. And I feel the trial closure of Broad Street has been successful. I think it's changed the ambiance of the whole area positively, and there are great opportunities to really do something special there. And I do, take on board the concerns of Chamber of Commerce and some of the businesses in the area, but we can address. I'll address that briefly in a minute. And I know that Deputy Morrell, who has taken over and making good progress with the future retail strategy, will have views as well. But what I think we all know is that pedestrianisation should mean pedestrianisation. People and vehicles don't really mix well in shared areas, sometimes very sadly, with tragic consequences. So we have to be, I think, extremely careful and use this opportunity very carefully. As the Constable just said, there are opportunities to make sure we have far better public transport options without having to traverse the whole length of a pedestrianised area. And there are great opportunities for further development of the public realm in that area. We can really do something special with Broad Street, especially with all of the plans that are afoot for new commercial premises, hotels connecting up